In this video, I'll explain how to obtain power of attorney in Georgia. I'll cover the types of power of attorney, the essential requirements, and the benefits of using statutory forms. So by the end of this video, you'll be able to confidently create your very own Georgia power of attorney. And by the way, if you would like to get help creating power of attorney, I recommend you contact people from lawdepot.com. They are professionals and they will be able to help you with your power of attorney. I'm going to leave a link to their website down in the description of this video. And with that in mind, let's jump right into it. Understanding power of attorney. What is a power of attorney? A power of attorney is a legal document that grants one person known as the agent the authority to act on behalf of another person known as the principal. To grasp the concept of POAs, let's explore a few essential terms. Durable power of attorney. This type of power of attorney remains valid even if the principal becomes incapacitated. Springing power of attorney. A springing power of attorney only becomes effective when the principal becomes incapacitated. Healthcare power of attorney. This type of power of attorney allows your agent to make medical treatment decisions on your behalf if you're unable to make or communicate those decisions. It is both springing and durable by nature. Georgia financial power of attorney basics. In Georgia, the laws governing financial power of attorneys are outlined in the Uniform Power of Attorney Act, founded in Title 10, Chapter 6b of the Official Code of Georgia. To create a valid power of attorney in Georgia, you must meet these four fundamental requirements. Principal signature. The power of attorney must be signed by the principal. If the principal cannot sign, another person can sign the principal's name under the principal's direction and in their presence. Witnesses' signatures. The power of attorney must be signed by one or more witnesses. Notarization. It must also be signed by a notary public or another authorized person capable of administering oaths. Importantly, the notary cannot be one of the witnesses. Presence. The principal witnesses, anyone signing for the principal, and the notary must all be present at the same time of signing. Georgia has simplified the process of obtaining a power of attorney by creating standardized forms for both financial and healthcare POAs. Under Georgia law, a person is considered incapacitated if they are unable to manage their property or business affairs due to an inability to receive and evaluate information or make decisions, even with technological assistance as determined by a physician or a licensed psychologist, being missing, detained, including incarceration or outside of the United States, and unable to return as determined by a lawyer, judge, or an appropriate government official. However, you can authorize someone to determine incapacity in your power of attorney. Georgia Financial Power of Attorney Form. The Georgia legislature has developed a statutory form power of attorney available in the Official Code of Georgia, Title 10, Chapter 6b, Section 10, 6b, 70. This form typically becomes effective immediately unless you specify otherwise in the Special Instructions section. For instance, you can make it effective upon your incapacity by including the appropriate language. This form includes various types of financial transactions, and you can grant your agent all these powers by initiating the line before the last item labeled all preceding subjects. Alternatively, you can choose which powers to delegate by initialing the line before each specific power. There's a separate section under grant of specific authority for extraordinary powers not typically granted to an agent. Georgia Healthcare Power of Attorney Form. The Georgia legislature has created a suggested Georgia Advanced Directive for Healthcare. This form must be signed and dated by the principal in the presence of two witnesses who also need to sign the form. Notarization is not required. You can find this form in the Official Code of Georgia, Title 31, Chapter 32, Section 3132-4. Why use a statutory form? Creating a power of attorney in Georgia using the statutory form increases the likelihood of acceptance, as these forms are familiar to both the business and medical communities. They come with valuable instructions and information. It's worth noting that a new statutory form POA form took effect on July 1st, 2017. Although previous Georgia POA forms are still considered valid by law, and out-of-state POAs are also considered, creating a new power of attorney using the current form is advisable. And don't forget that if you would like to get help creating your power of attorney, I recommend you contact people from lawdepot.com. They are professionals and they will be able to help you. I'm going to leave a link to their website down in the description of this video. I hope this video was helpful. Thank you so much for watching. Subscribe.